Hi, everyone. I am Dr. Dina Zuvala. I am one of the editors of Cell Dialogues, which is the renew and relaunch blog of the Center for International Law of the National University of Singapore. And today I am joined by Dr. Niloufar Oral, the director of the Center for International Law of the National University of Singapore, in what is our first symposium concluding event for the blog. So for those of you who have been following us, you must know that the past 2 weeks, we ran our first symposium entitled Climate Change in an Unequal World, Does International Law Matter? And in that symposium, we hosted contributions by Mr. Dylan Asafo, who unfortunately could not join us today, as well as Juana Uz, Margarita Wenwerke-Singh, Jolene, Lynn and Julia Dem, who could. And today we're going to have an event structured as a dialogue in a tribute to the name of the blog, to elaborate on some of the themes that we raised on the symposium, and perhaps on some of the things that we didn't have the space to do so. So very, very briefly, to introduce the interlocutors in terms of alphabetical order, Juana Uz is a PhD candidate at Harte School Center for Fundamental Rights in Berlin, and his research lies in the intersection between human rights and climate change law. And before that, he has had a long experience working in Ecuador on indigenous people's rights in Amazonia. Julia Dem is a senior lecturer at La Trobe Law School. She works on the urgent issues of international and domestic climate change and international law, natural resource government, and questions of human rights, inequality, and social justice. And her co-edited book, Locating Nature, dealing with many of these issues, was just published by Cambridge University Press, to be followed by Associate Professor Jolene Lin, who's also the director of the Asia Pacific Center for International Law. She also works on areas of climate change law and transnational environmental law, and she's the member of a number of editorial boards of very highly esteemed journals, including the Journal of Environmental Law, the Chinese Journal of Environmental Law, and Climate Law. And finally, Dr. Margarita Wenwerke-Singh, who is an assistant professor at Leiden University. She works on the role of law addressing sustainable development challenging, with a focus on climate change and human rights. And before her current position, she was a senior lecturer in environmental law at the University of South Pacific School of Law in Port Vila in Vanuatu. And of course, as I said, Dr. Niloufar Oral, with whom I had the pleasure and the privilege of co-editing this symposium. So we said we were going to work as a dialogue, so I'm not going to address any of the questions to anyone in particular, and please feel free to take any questions you find of interest. Please feel free to have follow-ups or to have comments on anything that is being said. And welcome, of course, to anyone who could join us. Before I get started, I also want to acknowledge I'm on the lands of the Navajo and Ngambri people, and sovereignty over those lands was never ceded. So the first question we had for you basically wants a little bit to elaborate on the theme of the symposium on climate change and inequality, right? So the fact that, as we know, we are in the particularly unjust situation in which those who have least contributed to climate change, both within and across borders, are actually those who are already and will be impacted in the future the most by climate change. So my question to the whole panel and to Niloufar, of course, was, how do you think international law is doing in addressing these inequalities of climate change? Has it been a source for moderating these inequalities, for exaggerating them? It has not had much impact either way. Anyone who wants to take this question, anyone who has thoughts? I think everyone is trying to be very kind, and I know everyone does have thoughts on that, but
I could go first if that's
please,
okay.
Juan. Yes.
Because I like general questions because I'm not very good with like very specific ones. So I just wanted to give it a shot. So thank you so much for the invitation. First of all, it's an honor to be amongst dear colleagues and amazing scholars like all of you. So I think that the international climate regime is particular in the way in which it was created and it, developed as in other international regimes probably in the past. Because I think that most of the countries, most of the states that are parties to the, a framework convention on climate change, of course, these are like fully sovereign post-colonial countries, most of them who are, of course, the most impacted by climate change. So therefore, there's an element of agency. And it's a very powerful element of agency, which, is manifested through, tactics like coalition forming, and which reflect their own interests. And that is, of course, reflected more specifically in the insertion of certain principles of international law within the regime. So I think that one of the most important principles for obtaining, or an aspirational principle for actual equality among states within the regime, is the principle of common differential responsibilities and respective capabilities. And this principle is kind of the fulcrum of many arguments that were made all across, over time during the formation of the climate regime. For the first time, of course, the bifurcation between developing and developed countries, and how these obligations were divided as well based on historical emissions. And this was also true for the creation and development of the Kyoto Protocol, and all of these mechanisms within the protocol. This, of course, was not necessarily true in the architecture of the Paris Agreement, in which this principle was kind of diluted because the obligations were widespread amongst countries. So this bifurcation was no longer there in the ways in which it manifested in previous agreements. However, of course, this principle has very serious limitations, and probably the most serious one is definitely political. And this political manifestation of this limitation is probably not necessarily linked to the regime of climate change itself, but to the architecture of international law itself. Because it's about, okay, countries are negotiating amongst them, but they have to achieve a consensus in the very end. And in order to do so, they have to fight and struggle, and they have to come up with compromises in the end. So it's like this trajectory and this inertia from previous forms of negotiation and inequality, of course, is reflected in the Paris Agreement as well. So I think that's precisely the reason why countries that will be mostly affected by the impacts of climate change are seeking new avenues to probably clarify these big principles. So to answer the question, probably, yeah, we have some tools out there, but there's mainly rhetorical tools. And these rhetorical tools have limitations based on structural inequalities that are part and parcel, of the nature of international law itself.
Thank you, Juan. Thanks very much. Anyone else who wants to draw either from anything Juan said, or add more parameters on the table? I think sure. Julia.
Sure, I'll jump in. I thought I'd start by just answering a slightly different question, namely, do we think international law has done a good job addressing climate change? Firstly, and then the inequalities that stem from climate change as well. And I want to start with some really sobering statistics that in 1992, when the UNFCCC was negotiated, CO2 parts per million in the atmosphere was 355. Now it's 417 parts per million. In 1990, we globally emitted about 35 billion tonnes of CO2. 30 years later, the figure's about 40% higher at about 50 billion tonnes per year. And what's really shocking, I think, is not only have we failed to stem CO2 emissions, we've failed to stem the growth in CO2 emissions. We're emitting more each year. So the economic recession caused by the pandemic was estimated to reduce emissions by 7%, but without this slowdown, scientists think that 2020 increase would have been the highest on record. As it was, even with the pandemic, even with all the lockdowns, it was the 5th highest on record. The only real dents that was seen in CO2 emissions over the course of the UNFCCC have been due to the breakdown of the Soviet Union, the 2007-2008 financial crisis, and then the COVID pandemic. And each time we see a rebound afterwards. There was a review essay published last year in the Annual Review of Environment and Resources, and they asked the questions of 3 decades of climate mitigation, why haven't we bent the emissions curve? And they look at this question through a number of different lenses. They look at questions of climate governance, the fossil fuel industry, geopolitics, economics, mitigation modelling, energy systems, inequity, lifestyles, and social imaginaries. And then the central thing they really come back to is the role of power. And they say this manifested in several ways: in dogmatic political economic hegemony, influential vested interests, and narrow technical economic mindsets and ideologies of control that have constrained the possibilities over the past 30 years. And I think when we're talking about inequalities, this question of power has to be so central. We know that the inequities of climate change are so evident in our face. We're seeing at the moment the devastation in Pakistan, for example, where 1/3 of the country is underwater, yet they've contributed less than 0.5% of global CO2 emissions. We know that it's the countries who've done the least to cause the problem of climate change who are most immediately facing those effects and most vulnerable to those impacts. But I think the central question too of political power has to be on the table when we're talking about these inequities. And that's, I think, so far what the international climate regime has failed to properly contest. Following on from what Juan's saying, I agree. I think combat differentiated responsibilities has been the key principle that has been adopted in the climate regime to try and address these inequalities. But combat differentiated responsibilities has always been subject to a constructive ambiguity. There's always been different interpretations of what this principle is about. Countries from the global south have argued that there are combat differentiated responsibilities due to the historical responsibilities that countries from the global south, north bear for the emissions that they have already emitted. And therefore they need to take a leadership role, they need to pay reparations, and they need to do more on mitigation. Countries from the global north, particularly the US, have always resisted this interpretation. They've accepted that countries from the global north have got a leadership role to play, but they've argued that leadership role is due to the lack of capacity of countries of the global south. And I think, we've seen how the framework, Kyoto is obviously the high point of combat differentiated responsibilities in the Paris Agreement, the mode of self-differentiation, where countries put forward their own nationally determined contribution, means that we don't have an institutional framework for assessing whether countries are taking on their fair share of mitigation commitments. But I think what we're also seeing is this sort of reframing of combat differentiated responsibilities, where there's a real focus more now on the lack of capacity of states in the global south, and that's being used or mobilised in ways, particularly by countries of the global north, then also in ways that further impose the same way that we see in the way in which development aid, structural adjustment programs are used to, in the name of assistance, to actually interfere in the political economy and regulatory infrastructure of other countries in ways that sort of impose a neoliberal political economy, which unfortunately is also one of the underlying causes of the climate crisis. So I think we're unfortunately seeing a twisting and a perversion of combat differentiated responsibilities, the continual denial of historical responsibilities, and the purported lack of capacity in the global south being mobilised by countries of the global north in order to push for reforms that I think are leading to more problematic outcomes.
Thank you. Thank you very much, Julia, for that. Before I move to the second question, I want to sincerely apologize for forgetting the other member of the panel, which is, of course, our editor-in-chief. What a person to forget. Dr. Martins Paparinskis of UCL Faculty of Law and incoming member, of course, to the International Law Commission from next year onwards. Martins, I hope I will not lose my editorial job after this. I wanted to pick up...
Not at all. I wanted to say that this surely proves that CAL Dialogues is truly an anarcho-syndicalist commune, and I'm merely the executive for the week.
That's true. I can confirm. So on that point, I wanted to pick up from something that both Juan and Julia pointed at, especially when Juan was talking about how states are looking to have some of these vaguer principles clarified. And as Julia perhaps was saying, also clarifying what is their foundations, right? Is it differential responsibility or is it differential capability? Which of course raises the question of adjudication when it comes to climate change, both before courts or, as we saw recently, before human rights bodies. So my question to all of you is, we know that states are pursuing at least 2 advisory opinions, one in front of ICLOS, one in front of the ICJ. And I wanted to ask you, in a sense, what are you expecting? What can we expect from these efforts? And more broadly, perhaps, what can we expect from adjudication within the broader legal, international legal framework in regards to climate change, and also between the broader effort against climate change? What is the role of adjudication in a nutshell, and what is the role perhaps of these efforts to secure the 2 advisory opinions? Anyone? I know that we had at least 2 contributions that focused very heavily on adjudication, so I'm kind of directing the spotlight.
I'm happy to jump in, and then of course I think Margarita should join in on the question of the advisory opinion, given her extensive work on that, especially in support of Vanuatu's campaign. So I think that, so thank you first of all for the invitation to join this dialogue. Really happy to be part of this. And I apologize in advance for sounding horrible. I'm just recovering from COVID. The idea of, I think the question for the $1 million question is, what is the purpose of an advisory opinion? What do we hope to get from it? And I guess if we want to be quite, there's of course the political significance. Secondly, the legal clarity. And thirdly, I guess there are what we call the indirect effects of having an advisory opinion. What do I mean by that? Well, first and foremost, if we ask for an advisory opinion, whether it's from the ICJ or from ATLAS, we all know that advisory opinions have to be very carefully crafted to ask questions that the court can answer, that the tribunal is able to answer. And that careful crafting in itself is a political exercise. It may end up that it does not ask the question that is of pressing desire, that there is a pressing desire for clarity on. For example, I would say there is a pressing desire amongst countries of the global south for clarity on obligations on loss and damage. That has been the one pressing and contentious issues in international climate change negotiations for decades. But because of the nature of the question, given the implications of an answer by the courts, the question is, will such a question dare to be asked? And if it were asked, what could it mean for the legitimacy of the court or the tribunal in the case of ATLAS? Secondly is on legal clarity. So take, for example, the argument that we should ask for a legal advisory opinion to clarify the scope of an NDC, so a nationally determined contribution. So the counter argument to that, I think, would be, why should it be the ICJ or the ATLAS that should pronounce on that when there is a perfectly, when there are mechanisms within the Paris Agreement to pronounce and clarify on this. It also could mean that, and so that's that to me is a question that needs to also, that has to be answered, and also perhaps leads to more questions than answers. I think the third one is really the indirect effects. The fact that there is a global clamoring by various sectors of global society, youths, activists, indigenous peoples, grassroots organizations, who want what they believe is a powerful international body to make a pronouncement on what they believe is important clarification. So with that, I'll hand the mic over.
Thank you. That was actually an extremely useful typology for thinking about it, and for thinking, that perhaps in trying to achieve one, we might lose a little bit of power on the other, and vice versa. Thank you so much, Jolene. Anyone else who wants to contribute to this question of adjudication, and specifically of the potential of getting 2 advisory opinions within the next few years?
I'm happy to say something, although it's very difficult to speak on this topic because we are in the midst of negotiations, and there is text that is being discussed, and so I have to kind of be careful when I speak on this. And of course, what I'm saying is all in my personal capacity, but just sharing a few thoughts. One is that I think it's clear for everyone who cares about climate change, climate justice, including states, that any form of international adjudication should help rather than hinder the negotiations. Any advisory opinion that would somehow undermine the norms and institutions that already exist on climate change would be unhelpful. So that means that I think there's a great desire amongst almost every state in the room, let's say, to make sure that a question that goes to an international court or tribunal is framed in such a way that obviously that is answerable. It's a legal question, but also in a way that is going to not lead to problems. And there can be all sorts of problems. But then again, there's a lot of scope for asking a kind of question that can bolster existing norms and institutions. And yeah, Jolene already mentioned a few topics that might benefit from clarification. And so one, I think a general thought is that there is, of course, the Paris Agreement, which is has many elements that were considered by the most climate vulnerable countries to be to reflect victories in a negotiation. So there's the long-term temperature goal, which includes, although ambiguously, but it does include the 1.5 degree limits. That was no non-negotiable ask in Paris. There is the principle of common but differentiated responsibilities. And we've seen from, for example, the judgment of the Supreme Court of the Netherlands in Urgenda, that sometimes a court can step in, and it can even be a domestic court in a developed state that steps in and says, well, actually this means partial fault means partial responsibility. There's a causation there is a link to historical emissions being made. So controversial in the negotiations. For decades, it wasn't really possible to make this link to historical emissions and responsibility explicit in negotiation texts. And yet you have a court stepping in and just doing that. So there is a scope for pronouncements that can be helpful. And then of course loss and damage. So we have Article 8 in the Paris Agreement. We have in decision CP21 this clause that says no, Article 8 does not involve or provide any basis for liability or compensation. So again, there is scope for clarification, and that could very well be, and probably most helpfully, could be not about interpreting provisions of the Paris Agreement, but about bringing together different areas of international law. So it's clear that the Paris Agreement doesn't exist in a vacuum, and it's possible to read provisions of the Paris Agreement in light of other norms and principles of international law derived from other areas. So, and we know, of course, all about the youth campaign around the ICJ advisory opinion, which focuses very much on human rights and intergenerational equity. And it may not be a bad idea to at least integrate those elements or related norms into the question that is asked to the courts. So, and when it comes to just then going back to the very first question, when it comes to inequality, international law, I think very generally speaking, again, international law does very well in setting like baselines for that's human rights. It's clear that there are certain minimum, standards, minimum levels of things, of rights that every individual enjoys by virtue of being human. Unfortunately, it does less well when it comes to rights of other beings, but for human beings, at least they're clearly defined rights. But of course, international law is much weaker when it comes to the other end of the spectrum. So when it comes to inequality, there's no cap on welfare of things that you can possess, and a lot of very damaging things are permitted under international law. And so, and perhaps the best, the kind of most useful hard law that exists is about responsibility for causing harm. And so that may also be where the greatest potential lies for courts and tribunals to step in and make pronouncements that can contribute to some justice.
Thank you very much for your insights, and especially given your sensitive position. Niloufar.
Yeah, thank you. It's very good questions, and I'm listening very carefully to these excellent sharing of thoughts. And I just wanted to add something. The fact that we have, from the Vanuatu side, it's a very youth-driven initiative for an advisory opinion before the ICJ. And also on the other side, there's also one by states, small island states, for an advisory opinion, possibly in front of ITLOS on law of the sea. Despite the inequalities, and there are many shortcomings with international law, particularly with the climate change regime that our panelists have discussed, there's obviously still some faith in international law. And I think that's something that we really should grasp. And I hope that the courts, if they are called upon and will be called upon, appreciate that this is an important moment for international law as well. Climate change is the defining issue right now of everything. It is cross-cutting. So the fact that you have young people and the smaller states, not the large, powerful states, the smaller states reaching out to the courts, to justice, I think speaks highly. And this is something that I just wanted to, point out as well. So I'll stop there.
No, absolutely. Thank you so much. And actually, this takes us quite smoothly to my next question, which was about how well we think, especially courts in international law can deal with these sort of public interest questions, right? Because of course, when it comes to the ICJ and advisory opinions, we know, for example, we have the precedent of the nuclear weapons advisory opinion, in which the perception is that it actually set back the movement of denuclearization rather than helping. So in the political typology that Jolene was talking about, actually it backfired quite badly. And I mean, of course, there were raised questions by issues by Jolene and Margarita of drafting and putting a question that the court will be able to answer, and will be able to answer in a way that it doesn't do, at least, first do no harm. But I was just wondering about any of the panelists' insights on the ability of courts, in a sense, to deliver justice and to deliver actionable legal principles, not only for individual cases, but for broader public interest issues. Of course, keeping mostly in mind climate change, but we could have this broader discussion about other issues. I was wondering if any of you has any thoughts on that, especially in light of the ICJ record being, let's say, spotty.
Well, if you look at the recent pronouncement by the UN human rights body on the Torres Strait Islanders complaint against Australia, it's actually a really interesting, I would say, a very interesting pronouncement by the Commission. It's very open-ended. It actually, and also holds, for the first time, holds a state responsible for causing harm and infringing on human rights because of their irresponsible behavior on climate change, and also for the first time states that a state should pay compensation for causing climate harm. I think we have not had very big. We haven't had much opportunity to galvanize indigenous people's rights in international law to address climate change, and I think this is a wonderful moment where it's in the spotlight. As for the spotty, record, I think that's a really great question. It points to a lot of the discussions right now in strategic litigation circles. How do we ensure that you don't have a test case or a case that not only ossifies the law, but actually sets us backwards? And as Margarita has mentioned, also does not help negotiations, but actually hampers negotiations. These are big questions that are being thrown around and discussed to no end. And also in terms of how it interacts with domestic litigation. At the moment, there are at least 500 cases pending in various courts around the world. And all these, the temperature is being taken across the landscape to figure out when is the best case, what is the best case scenario, and when should we be filing a case at, would an advisory opinion help, for example, courts make more ambitious pronouncements on climate change? It didn't need an advisory opinion for the Supreme Court of the Netherlands to rule as it did. But hey, it could be that an advisory opinion could strengthen the hand of another court.
Thank you very much, Jolene. Anyone else who's interested in, I think Julia.
Well, I'll just jump in, and I think sort of kicking off from those really interesting comments too about the decision that we saw last week around Australia. Again, so exciting having, the first decision really holding a state accountable for breaches of human rights for climate change. But then at the same time, I think this is similar to what we'll see with an ICJ advisory opinion, that I'm really optimistic that it will be a decision that will move things forward and hopefully progress things in positive ways. But I think there'll be real limitations to it as well. And I think the real limitation that we saw with the human rights decision last week too was the real focus on adaptation and the failures of adaptation policy rather than mitigation. And particularly in a context where Australia is one of the highest per capita emitters of CO2 in the world, where we've got 100 new fossil fuel projects in the pipeline, with our coal exports and gas exports currently times our domestic emissions, projected to become 3 times our domestic emissions. None of that's counted as part of our Paris Agreement. In this context, Australia is doing horrendously on climate mitigation and really needs to be held to account for that. So as exciting and groundbreaking as this decision was, and particularly I think those aspects of compensation as well, and that focus that states have these responsibilities adaptation, I think there was that real limitation in terms of naming those mitigation questions. And so again, while I'm really optimistic about what could come out of an ICJ advisory opinion, and I'm really optimistic it could move things forward, I think there are going to be inherently real limitations. I think 12 scholars have made really clear to us that international law was forged in the colonial encounter, that the key concepts and doctrines of international law are products of that colonial encounter, and that international law has developed certain mechanisms to prevent reparations for historical harms, that getting that compensation for historical harms has been, difficult in all areas of international law. I think we're going to see that again in climate change. And so I think, that at best it could provide a remedy, maybe move us forward about what current obligations are, but I don't think an advisory opinion is really able to address the really multifaceted, complex historical justice issues that climate change raises. And I think that then becomes to a question of climate justice movement strategy, that we use these opinions, we mobilise them, we leverage them as much as possibly can be, but that we also articulate more broader, more expansive, more imaginative discourses of justice that go beyond what the frameworks of international law can offer us, and that have got a more decolonial vision at their heart as well.
Thank you very much, Julia. Thanks. And yeah, as you also, I think, pointed out in your contribution, right, questions of like intertemporal law in terms of state responsibility can pose very severe limitations in both adjudication and more broadly legal advocacy on that front. Anyone else who wants to discuss the matter of? Yes, Juan, please.
Thank you so much, and apologies because I think my internet is a bit unstable at the moment. So yeah, I just wanted to say that all of these questions about the potentials and possibilities of international law to deal with such a wicked problem at the global level is all about, right, expectations. What do we expect from the international legal order? And based on previous experiences, I guess that there's not much we can actually expect from it. And I say this because, I don't know, we can talk about the expectations that we have in, I don't know, how cross-fertilization might be an avenue for, learning collectively amongst international tribunals. So, for example, the question of extraterritorial obligations in human rights law was pretty much settled, at least at the European Court of Human Rights level, with cases like Bankovic and Alskany and so on. So we know that this matter was, of course, super limited. But then, we have the advisory opinion from the Inter-American Court on Human Rights, which expands like quite profusely the concept of extraterritorial obligations, which is no longer, the remit of territory and agency of state agents, but also is mainly the source of harm that constitutes the extent to which jurisdiction can actually reach. And I think that that's a very important matter, because if we believe in cross-fertilization, that this is happening, this idea of an advisory opinion from one region cross-fertilized with the understanding of interpretation of law by other international tribunals like the Human Rights Committee took on board these notions from the Inter-American Court, and that's positive, of course. Probably the International Court of Justice might also rely on these emerging notions of expansive extraterritoriality to chip in the concept of due diligence and to interpret the concept of due diligence in light of the distribution of burden sharing in the context of greenhouse gas emissions and in the context of a global carbon budget, for example. That could be the case, hopefully, if our expectations are very high. On the other hand, if we manage our expectations based on previous or past practice, and we talk about, for example, reparations for climate-related damages. Even the Inter-American Court of Human Rights, which some say that is very progressive in this sense, has had some, fundamental problems in assessing the degree on which how they can measure the compensation for damages, and includes, including in indigenous people's rights cases. It has been very problematic for the court to establish the degree of damage and which methodology they should use for this. And it's a very contested ground, a very contested field for the judges to determine this. And this also happened with the ICJ when they determined the environmental damage in the Nicaragua, Costa Rica cases, because they had to compromise on a certain methodology to assess the value of nature and the value of damages that has to be compensated. So imagine this very particular case of a very, specific, environmental degradation case. It had lots of problems, dealing with the methodology. So just, extrapolating that to a global wicked problem like climate change, in the context of, for example, reparations, I think that will be very challenging for the ICJ, and probably would be detrimental as well for the climate regime in general, because if they set a very conservative type of methodology to assess damages, then probably that will set us back a lot. So I think that's a risk. But as far as managing expectations are concerned, and we have to try to balance what happened in other courts and what happened within the ICJ, for instance.
Thank you very much, Juan. And yes, Niloufar, please. You are muted.
I think Margarita also had her hand up, so I would rather defer to our contributors first.
Well, you can both, Margarita can go first and Niloufar after.
Yeah, I guess I do want to add two perhaps optimistic notes on this point, which are basically about strategy. So first is, of course, the two initiatives of COSIS and of Vanuatu and friends and the youth are aimed at seeking an advisory opinion, and so they're not aimed at bringing contentious cases, and that is a critical feature of the initiatives. And so unlike in a contentious case, there is no need for either tribunal to develop a very detailed applied methodology for assessing damages, for example. And so that then also avoids some problems and risks, these initiatives. So that those are, of course, the strengths and weaknesses at the same time, that the opinions will be advisory and universal generic. And so they will raise a lot of new questions because it's not yet clear how they will apply to particular factual situations. But I think one reason why this strategy seems a wise one to pursue is that it kind of takes an incremental approach, right? First, setting the general parameters and principles, etc. Well, hopefully then no further litigation will be needed and all states will start to work within these parameters, etc. But should there be a need for further litigation, then there is something to build upon. And we see also, I think the Torres Strait, the Human Rights Committee's views in the Torres Strait case are also a very good example of how an incremental approach delivers and also fails to deliver on some fronts. But you see from, I think there's a very clear line between the general comments and then the Taitiota, the committee's views in Taitiota, which, as we all know, succeeded on admissibility, but it failed on the merits. Quite, disappointing on some points, but there's still, the Human Rights Committee deliberately gave itself a step to something to build upon in the next case, and did that then, and found violations, at least in the Torres Strait Islands case, based on those the principles. It's very clearly and very, very deliberately building on its own prior work. And I think, Juan, your point is also very important about cross-fertilization, and also the point that international bodies seem to be recognizing that there is a need to depart from established unhelpful interpretations of the law in some cases. So I think one of the clearest examples is the Committee on the Rights of the Child's views on the Saki versus Argentina, where the committee deliberately explicitly says that the Bankovic jurisprudence, all of this unhelpful European Court of Human Rights jurisprudence on extraterritorial obligations, is not applicable. This is a different kind of problem. And so banks in a footnote, and it's parked and put aside. So that's very useful. Now, coming back to the strategy, so I mentioned the strategic choice of focusing on an advisory opinion rather than a contentious case. Of course, there are more reasons for that choice, but one has to do with these risks, etc. And then the other one is the bottom-up nature of these initiatives. As I think the world notices, these initiatives are driven by primarily initially by SIDS. And then the coalition that is being built is one of climate vulnerable states. So we see, of course, this is most relevant in case of the of Vanuatu's initiative, which seeks to at least secure a simple majority of votes in the UNGA. And then, as the world is noticing for sure,
I think we've lost Margarita, or at least I have lost her.
Support for
Margarita, I think I have lost you, and I think is that a case for the rest?
Frozen. Oh, she's back.
Yes, could you repeat your last sentence, Margarita, because you froze a little bit.
Oh, I'm very sorry.
No, don't worry. It's the era of Zoom.
So yes, the coalition that Vanuatu is building is made up of climate vulnerable states, and so the Organization of African, Caribbean, and Pacific States, as well as CARICOM and the Pacific Islands Forum, have endorsed the initiative. So just the OACPS has 79 member states, and so you see that it is possible, at least in theory. Of course, we have to see which states are going to be present and press the green button. But at least in theory, it's possible to build a coalition of states that have very similar interests in a particular type of question, in a particular type of opinion. And so perhaps that makes it less messy, and that makes it more likely that it will be possible to put to the court a question that is formulated in a very helpful way, and doesn't have too much ambiguity that then creates risks of bad outcomes or underwhelming outcomes.
Thank you very much. I think that it was very optimistic by being very factual, which was, I think, is the best kind of optimism. Nilufer.
Yeah. Thank you. And I think I'll follow up with Margarita on the same more optimistic note. Yes, perhaps we have some advisory opinions that were not the perfect outcome, but even the nuclear advisory opinion, it is cited all the time, not because of the final outcome, but because it's solidified and confirmed as customary international law, the duty of states not to cause harm, transboundary harm. Very important. It also recognized, and is so often cited, it's famous, you know, the environment is not an abstraction, and it goes on. We have other advisory opinions that have also been very important. On the Genocide Convention, again, the issue of erga omnes obligations, which we see so important, the wall. So I really think that what we have to look at is how ultimately these advisory opinions are used. Not what their actual outcome turned out to be, because no one cites the nuclear advisory opinion for what the outcome was. They cite it for something else. So I'm going to be a little bit more optimistic. And I also think the timing, the context, you have to look at all. It was very different. You've got, you know, the superpowers involved there. And here, that's why the question does become very important. You have to be very careful, and I'm sure that that will be the case, that you ask the right question. And I know another example, and that has to do with ITLOS, the very first advisory opinion for the full bench that had to do with IUU fishing, a concept that is not in the Law of the Sea Convention. But it was a great opportunity, and I think successfully updated the convention. So I'm a little more optimistic on it, but the question is critical, the timing is critical, but I think this is the right time now. You know, I think the right momentum is being created, and I'm sure that the right question will be asked on both counts. And one last thing, because I know we're running out of time. Another example, though. So this recent case that came out of the Human Rights Committee, very important, because just before that, you know, you had the New Zealand Te Tota case, which was, I guess someone would say, a bad result. It was not a good decision. So I don't know, you're seeing now, you know, a change in, well, let's try and have now a positive pro-climate decision. That was kind of a bad one. So the context, I just think that we're in a time now that it would be really hard to give a bad, it would be bad to give a bad decision on climate, but the question is important. So I'll stop there.
Thank you very much. And I guess we will be having this discussion in a more informed way in a couple of months when we actually do find out what the precise question will be. I was hoping to ask one more question, but I think I will not. And instead, I will give the floor to Martins for perhaps some final comments and thoughts to conclude this discussion.
Well, thank you, Dina, and thank you, contributors. It was so wonderful to have you contribute to our first symposium and putting as well trust in us. I think the theme of CIL dialogues is, as we explain in our vision statement, drawing somewhat on the late and great Judge Crawford, is of international law as a process of claims and counterclaims that are often re-elaborated, even if sometimes they do stick if established in a particularly authoritative body. And I think that is also one theme that I heard running through about different choices and different advancements and different values. And even though I will probably be the last or the penultimate to speak, it is absolutely, even though this discussion has to end, the dialogue absolutely continues. So we are part of the bigger process. I have so many notes. You have been also absolutely fascinating, and I'm sure that other listeners will agree with me, but let me try to make 5 points. Vanuatu has been mentioned several times, and I had the pleasure of speaking in the Lisbon Ocean Conference, where Vanuatu was the first intervener on the particular panel on behalf of small island developing states. And it was a short intervention, but sort of the punchline, the last 2 sentences were precisely about support to the International Court of Justice request for an advisory opinion. And I think that speaks precisely to the point that Linolfer made. Trust in international law. I think it does not need to mean unjustified trust. So I think that Juan's point that international law may be unhelpful is also perfectly right. It can also be helpful, as others and Margarita suggested. So perhaps I think I could slip in here the obligatory reference to the promotion of greater happiness as a UCL staff member and an occasional opportunistic utilitarian. That, I think, international law as an instrument that may do good things and may do bad things, and it reflects on the good judgment as well as expertise of the framers. And I think what we have heard of the discussion so far makes one quite optimistic about those involved in the project. So that, I think, was sort of my bigger takeaway. The second, and perhaps sort of going from the more general to the more particular, the bigger theme of inequality and the variety of ways how international law may address inequality with benefits and costs. I think, generally speaking, we can think of inequality as a factual matter that may be not necessarily addressed at the level of vague primary rules themselves, but come in at the moment of application. So in a sense, it is something that the particular law application institution identifies as irrelevant. It is something, and so the common and differentiated responsibilities discussion emphasize that it can already be articulated explicitly as a consideration in the rules. And of course, there were multiple nods to the institutions already in existence for Paris Agreement. It may be that this is something that is directed at the institutions. And of course, we cannot exclude the possibility that these things flow from the basic foundational principles of international law, as it were, the constitutional foundation of international law. Although there, I have always felt that there's a slight tension with the principle that is also extremely important for the developing world and the global south of sovereign equality, not to introduce a variety of categories of states, which is certainly not a path in which one would want to develop the international legal order. So in some ways, articulating these things through the political choice of crafting and applying regime may be the more attractive one. And I think that that is probably the argument where we are mostly going. One direction we can go is through domestic courts, and I think there are some of the great judgments already noted coming in a global way, and I think that that is really the fascinating point. It's not really just a Western European or North American thing. I suppose perhaps somewhat in the geographical sphere, I remember an article by my former colleague Roger O'Keefe about the contribution of domestic courts to international law of jurisdiction, where they really have had a great deal. And Roger, in his, calling spade a spade way of approaching things, one of his opening sentences was, we shouldn't necessarily assume that all domestic judges are international legal ignoramuses. So that was sort of, the best thing that he could say. And, that he explained and qualified in various ways. But I think perhaps there needs to be that, slight caution about the way how things go through domestic courts, where they are shaped in a different procedural context and do not necessarily fit in elsewhere. So far, of course, that has not been the case. The discussion on international courts was a fascinating one, and I really see a symposium topic possibly in the future. What opinions are successful and what are unsuccessful? How do we count what matters for success? And I think some people might say, paradoxically, being very successful legally speaking might be a seed for politically problematic solutions. So some people would say that the Israeli wall advisory opinion, even though legally extraordinarily successful for those requesting it, was so out of hilt with the broader United Nations legal process that it really did not deliver on what was requested, perhaps because it was so good. It was too good to fit within the process. And conversely, some people would say that the more perhaps modestly drafted Chagos request provided a forum for the broader community to express its views and actually goes with the grain of the political process. And again, I think that that is something that clearly the very sophisticated expert groups working on this are very attuned to. But again, an open question. I thought that that was a fascinating bit of the democratic nature of our editorial team, that we can profoundly disagree on what works and what not. I think the reparation for climate-related damages is a fascinating topic, and the way how the liability within primary and secondary rules ran in parallel, but then diverged in the 1990s International Law Commission is an interesting story. And I think that B.S. Chimney recently wrote some interesting things on how these matters work. Regarding climate change, but I suppose in other fields as well, perhaps these are things that are really elaborated fundamentally through application rather than through the abstract a priori reasoning. So more cases mean better application, albeit with a reminder to the first principle of international dispute settlement that Eli Lauterpacht said in his Hague Academy course on international courts. The first principle for the international court is never go to the international court if you can help it. But I think probably the takeaway that we had that we probably cannot help it. This is a time when all instruments and courts have to be on board. And that is it for me, and back to you, Dina.
That was outstanding timing. Thank you, Martin, so much for summarizing the discussion, but I think also for moving it forward in such a productive way. Thanks to all 4 contributors and to Dylan, who could not join us today. Thanks to Nilufa for her contributions and also for all the work for putting the symposium together. And I'm going to suggest, totally go off script, and maybe suggest we should have another discussion when we actually do know the questions, and we can have this discussion in a slightly more informed way. Because I think it does, as Martin's pointed out, it does point, I think many of you pointed out, it does raise a lot of questions about how we understand the role of courts, how we understand the questions, and how we understand perhaps, do we prefer a maximalist versus minimalist approach in adjudication, which doesn't necessarily, I think, automatically mean maximalist or minimalist position in terms of legal or political strategy, right? I think that's the interesting thing there, that a minimalist question might help a maximalist project and vice versa. Thank you all for the time. Thank you to all attendees who stayed with us until the end. The symposium currently going on seal dialogues concerns a historical issue, but with great contemporary significance, which is World War II in Asia and international law. I urge everyone to go and have a look. Thank you for your time. It was great chatting.
Thank you, Dina.
Have a good afternoon, morning, or evening, wherever you are.
Thank you, everyone. Thanks to all. Thank you so much.
Thank you.